A couple of weeks ago, when Kara joined us, she mentioned a letter the board had written to the Democratic Women's Caucus calling attention to its statement on the recent Title IX rule changes that neglected to mention the fact that the new rules redefine sex to include gender identity for all Title IX purposes. We thought this omission was significant, not only because the redefinition will have disastrous consequences for women and girls, but because evidence suggests that is not well supported by either House or Senate Democrats, not to mention how deeply unpopular it is with the general electorate. The letter goes on to reference Reem Al-Salam's strongly worded statements denouncing the Title IX rule changes, and Joanna Cherry's impassioned speech to the Scottish Parliament on Lesbian Visibility Day, as well as her expressed willingness to meet with female members of Congress to discuss these topics. We proposed such a meeting to the caucus and encouraged a response by May 17th. As anticipated, the DWC has not responded, so today we made good on our promise to make our letter public. We are now inviting a global response and asking our sisters to help us bring as much attention to the situation as possible, and by contacting the DWC directly to share your concern about its glaring omission, and I'll put that link in the chat. Your support would be much appreciated. Next, I'd like to give a shout out to two WDI USA volunteers in Georgia, whose advocacy among Georgia Greens resulted in the party retaining its support for the declaration as a plank in their platform, which was voted on at its nominating convention held on the 17th, or on the 18th, excuse me. Their advocacy was in response to a platform proposal to strike endorsement of the declaration, as well as other language opposing the medicalization of children from the human rights section of the GGP's platform. Two public hearings were held to discuss the proposed amendment, where Heather Brunskill Evans and Jamie Reed, the St. Louis Gender Clinic whistleblower, were asked to present their respective expertise on the matter, which evidently persuaded Georgia Greens to reject the proposal. On the 13th, the New York Times published its interview with Dr. Hilary Cass titled, "Hilary Cass Says U.S. Doctors Are Out of Date on Youth Gender Medicine." Unfortunately, it is presented as sort of a he said, she said scenario with regard to her findings being virtually ignored by groups such as the AAP and the Endocrine Society here in the US. Next, more damning information has surfaced about WPATH, emails between Johns Hopkins and the HHS's Agency for Healthcare Research and Quality, released last week as part of an ongoing legal case, reveal that WPATH, after hiring experts at Hopkins to perform a systematic review on the evidence for gender-affirming care, not only did not apply the results of that review to the organization's 2022 recommendations, but restricted the Hopkins researchers' ability to publish their findings, namely that they found little to no evidence about children and adolescents. Lior Sapir published an article last week discussing the Biden administration's recently finalized regulations on foster children, who he describes as new pawns in the gender wars. The new rules condition federal funds on support for a child's proclaimed gender identity, and in his words, are guided by misleading characterizations and omissions of existing research that entrench the idea that failing to affirm constitutes abuse. 18 states have filed a lawsuit against the Biden administration's Equal Employment Opportunity Commission, EEOC, seeking to block the recently released workplace guidance to prevent harassment, which forces women to share bathrooms and other women-only spaces with men at work and compels workers and customers to use inaccurate pronouns or face workplace harassment claims. 4 more attorneys general in Kansas, Utah, and in Kansas, Utah, Wyoming, and Alaska have filed suit in federal district court in Topeka, Kansas, against the Biden administration over its recently finalized Title IX rules. Lead Attorney General Chris Kobach stated that the Department of Education has no authority to do what it is attempting to do, and also that the unconscionable rule was in conflict with Kansas law prohibiting males from competing on female sports. Sadly, this week, Wolf received the disappointing news that the district court dismissed Chandler versus CDCR on procedural grounds. Wolf filed a suit on behalf of 4 incarcerated women challenging SB 132, the California law allowing men to be housed in women's correctional facilities. Wolf is said to be reviewing the decision and considering their options for next steps in the case. And last but not least, in a significant legal victory for detransitioner Prisha Mosley and her lawyers, a North Carolina Superior Court judge has ruled that her case presents sufficient allegations to proceed against multiple doctors and health facilities, despite defendants' motions to dismiss. According to her lawyer, this is the first substantive ruling we are aware of in which a court has held that a detransitioner's case against her healthcare professionals is legally viable. Thank you.